Yes, sir.
Yes,
Yeah,
yes.
yeah,
Okay,
it's
thank you.
audible.
Uh, I request like all of you or some of you who can switch on their camera because I'm the only one visible to myself. It's very difficult to talk when you are talking to yourself. Uh, Thank you, sir. Thank you very much. Because nowadays, sometimes these meetings, like you are the one and you are facing yourself. How to talk for 3 hours? Okay. Uh, so the topic today is negotiation, mediation, and kind of ADR. So I'm a mediator. I'm a trained mediator. I have taken the training in the Supreme Court and I'm doing mediations in the Supreme Court of India. I'm on the panel of the Supreme Court Mediation Center. So this session, I wish to keep it more interactive and less like a monologue. So if any of you have any of the questions, most welcome. The more questions, the better it will be. There is hardly any formal literature which can be given on the negotiation because all of you, before becoming the IP, has been doing this job for a very long period of time. So the negotiation remains the same, and so is the mediation and the conciliation. Uh, so let's start with the formal part of it. So in India, there is uh, only one recognized course which can make you a mediator. That course is imparted by MCPC. MCPC is the name of a committee. This is run by the Supreme Court of India. And basically, what they do, they give a 40 hours of the training, roughly 40 hours, maybe 48 or something. And after you successfully complete this 40 hours, roughly translates to 1 week course, then you are supposed to carry out at least 20 mediations, out of which 10 has to be successful. 10 could be a failure one. After completing 20 mediations, they will impanel you as a mediator. So that's the formal route of becoming a mediator in India. This committee functions across all the courts, including district courts, high courts, Supreme Court, and all kinds of matters are coming before these mediation centers. So the mediation as such has a very long history. Some people like to connect it with the Mahabharata, where
Hmm.
like the Lord Krishna tries to mediate between Kauravas and Pandavas, or arbitrate or mediate, whatever like one would like to call that. It's a form of alternative dispute resolution. So this is the broad umbrella under which mediation and conciliation is marketed. So there are three limbs, three, four limbs to say. So the most known ADR is arbitration, then conciliation, mediation, and expert or neutral determination. So to start with, what is the difference between all these? Arbitration is basically
Sir, what is the
resolution of
fourth one? Can I? Arbitration
neutral
and
neutral determination or expert determination.
okay, okay.
Thank you very much, sir, for the question. I really feel like at least there is somebody who is paying attention.
Now will be other user.
No,
Who
no,
will
no.
be other
Everyone
user?
is attending. Everyone is very keen. Don't take it otherwise. He is noting down everything. We think that we get the PPT, so we'll have a look at the PPT. That's the only difference between us.
Okay.
He notes down. Okay.
So the PPT preparation is too much easy. I thought it's better to speak
I
from
agree.
like what I have learned. So
If PPT is shared, it will be useful for us in the long run, right?
I'll share the PPT as well. So arbitration, what is an arbitration? In a formal sense, it is a determination like a court but judge is not subsidized or given by the court, but paid by the parties. So that's what the arbitration is in the extremely simplistic term, where the parties decide that this person will be fair, and both of them pay this person to decide the dispute in accordance with the law. If this kind of setup is adopted, this is arbitration. So arbitration is binding, and there is an entire act on it, Arbitration and Conciliation Act, and therefrom the second limbs come of conciliation. So in India, first the mediation was not recognized as such. The conciliation came first. So what is the difference between mediation and conciliation is another key thing which a lot of people ask. So mediation and conciliation is the same. The only difference is that conciliation is more formal in nature. So the distinction between the two branches is just very thin, and they entirely overlap between both the streams, whether it is a mediation or a conciliation. So right now there are two statutes which exist. One is Arbitration and Conciliation Act. There is an entire chapter which is devoted on conciliation and arbitration. Earlier, there was no statute regarding the mediation. There was only one provision in the CPC which empowered the court to refer the party to the mediation. But now there is a statute, however, not fully implemented, in the sense that it's still like forced by the court, and no longer the lot of mediation centers are not coming up as such as they were supposed to. So the conciliation and mediation. And the last one was the neutral determination. The question was there. So neutral determination is the one in which what you do is you don't go to decide your dispute like an arbitration. You don't want a binding award, but both the parties wants that this person should give us what is the fair in accordance with the law. So they go to a parties, they get a decision kind of sort of thing, which is not binding on both of the parties. This is called neutral or expert determination. Expert determination is normally used in hypercritical matter where the subjects are very technical. And even in the normal case, the people can go to it, resort to it, but the decision remains completely discretionary or parties whether they want to follow or not. So this kind of things are hardly like reported or taking place in the formal domain. Today's topic is limited to mediation, conciliation, and negotiation. So mediation and conciliation is one or more the same thing. Why the people should go to the mediation? This is the first question which comes up in the mind of everyone. One, which is the obvious reason for which the 90% of the mediation take place, is the court forces the party to go to the mediation. So for example, if anyone wants to invoke the jurisdiction of any commercial court in India, it is mandatory for them to go to the mediation first, if they are not asking for any interim order. To explain it in other terms, so suppose there is a dispute between the parties regarding a property of, say, 5 lakhs rupees. It becomes a commercial dispute. Now both the parties is contesting over the title. So the party who does not have the title wants to go to the court. It says that the possession of the property is with the other party. I am the owner of the property. Please determine the dispute. So if it is a simpliciter prayer of resolution of dispute, then the court is bound to refer these parties first to the mediation. This is a formal mediation which happens by the mediator appointed by the court. Only when the mediator says that despite my best efforts, the parties have not settled the case, then the case is listed before the court. If the mediator says that the parties have resolved the dispute, then whatever is the terms of the settlement are written down on a document which is forwarded to the court, and it becomes the decree of the court. And it is directly enforceable, and you can take it in the execution. This is the first reason the people go. Now, the second limb of argument, when this is not mandatory. So we have taken an example where the two parties were contesting over the title dispute. One had the possession, one did not have. So first, in the first case, the suit was filed by a person who did not have the possession. Assuming the otherwise, the person who has the possession wants to file a suit, says that other party is trying to dispossess me by help of some third parties or gundas or somebody, please protect my possession. In that case, there is a relief of urgent nature which the party is desiring. Since there is a relief which has been sought and which is urgent in nature, even without referring the dispute to the mediation center, the court will take up the matter, because they have to pronounce whether the prima facie case is made out or not. So this is when it is forced, when it is not forced in the court. Then voluntary, sometimes the parties goes to the government assisted mediation center themselves. A lot of these cases, now there are thousands in numbers.
I think
where
something
the
wrong with your side.
government-
The Wi-Fi is not all right.
Okay, I'll try to log in with another computer. I'll
Yes.
just give my okay.
There is a delayed distortion.
Okay. Let me try something else. Just a second, sir. I'll just try to copy link. Okay. So join. Is it better now?
Yeah.
Okay. So if the parties decide that they themselves want to resolve, the government, particularly in some states, I'm not sure about all the states. So take an example for Delhi. There are dedicated mediators, which is appointed by the government, and they try to resolve the dispute between the parties. So these are the methods where the parties can approach. Why the next question which arises, why the parties should go to the mediation? So one of the advantage of going to the mediation is that the dispute remains private between the parties. So for the largest number of the cases which are being referred to these mediation centers are matrimonial disputes. The dispute is private in nature. Number of the times parties do not want to disclose all the intimate details or what has happened between the parties. And the parties can discuss it freely. What I mean by freely is, one, none of the statements which are made before the mediator are supposed to come into the public domain. So suppose there is a commercial dispute between the parties, party A and party B, and one party says that though I have filed a claim of say 50 crores, but my actual amount is only 5 crores, rest of it is interest which is unproven, undocumented. The parties may or may not give any consent or give relaxation during the court proceedings, but this can be admitted in the mediation proceedings. Now, assuming that the mediation fails and the matter goes back to the court. If the matter goes back to the court, the mediator or any of the party is not allowed to take benefit of this particular statement given by one of the parties who has said that my total amount is not 50 crores, but say only 5 crores. Rest of it is undocumented or whatever it may be. So the dispute remains private. Even if say matrimonial dispute, whatever happened between husband and wife, there are allegations and counter allegations. They are never disclosed to the court. In case the mediation fails, the mediator can only say in its report that he has tried his best, but despite his efforts or the efforts of the parties, the dispute could not be settled. No information goes before the court. The only thing which goes before the court is the settlement between the parties. In case they reach a settlement, then only the settlement is recorded and it goes before the court. So this is why one of the key reasons the parties should adopt the mediation. It's 100% confidential. There was a case in the Supreme Court itself. Supreme Court appointed a very renowned person as a mediator and referred the parties to the mediation. During the mediation, several allegations, counter allegations were made. Thus, the person perhaps did not go through the mandatory training. He wrote a detailed report and sent a detailed report despite the failure, saying that this party said this, and this is the one who is coming between so and so and so. The Supreme Court gave a detailed judgment on this issue, said that as a mediator, come what may, even if the Supreme Court says that file a report, it only means that you are not supposed to disclose what happened between the parties. So that particular judgment set a precedent for all the mediation. It's 100% confidential. Second reason why the parties go to the mediator. So there are lots of advertisement which is going on by the government to promote the mediation. These advertisements says it's preserve the relationship. How the mediation preserve the relationship? So in one of the cases, I was a mediator. In this case, this was a property dispute between the parties. One friend has lent money to the other person. The other person says that you can't pay, you just mortgage the property. And since there was no mortgage, he directly got a sale deed executed, kind of thing. No payment was made. Dispute ultimately came up to the Supreme Court after the litigating for 20 years and 30 years. Ultimately, during the mediation, when the matter was settled, both the person shook their hands again and parted away with the money, whatever they decided to divide between them. So the best part is that if the disputes get settled without contentious means one party is right, other party is wrong, then there is an acrimony in the heart of the person who loses. In mediation, there is no sense of loss between the parties because they feel that it is we who have negotiated the settlement and it is fair to us. So even if there is some kind of concessions are given by both the parties or sometimes one party to the another, there is no sense of loss or harna jisko bolte hain. They don't feel a complete loss at all. And in business relationship, the things continue. Even in matrimonial relationship, as a mediator and as a counsel, my experience was that the parties forget that whatever bad happened with them. So long time back, I was as a lawyer representing this one of the party's husband. He was a government servant. There was a dispute with the wife's short-term marriage. There was the marriage was with a lot of spending and everything. When it did not work out, a huge amount was asked in the mediation by the wife. Ultimately, during the mediation, the things got settled. The parties decided to quash all the proceedings, including 498A, dowry, domestic violence, maintenance, divorce, restitution of conjugal rights. So when husband and wife fights, there is some people says it's a 6 in the cricket, like 6 proceedings comes by one dispute. Custody, sometimes it goes to like 54 cases. The highest I have seen in husband and wife is like they were fighting 54 cases in between. So there was a great amount of vision in their head to come out with so many litigations. So in that particular litigation, when the matters get settled, it so happened that we were standing in front of the parties. The mother-in-law was sitting in between. One side the husband was sitting and one side the wife was sitting. This was the final proceeding after the divorce was finalized. And they started talking to each other. And they were talking so happily that after half an hour, the mother-in-law says that if you can talk for half an hour so well, why didn't you get married again? That was the day when they got divorced. So the best part of the mediation is that come what may happen, the relationship is preserved, and that's why it should be promoted. The third thing, there is a misconception or wrong assumption between the parties, or even sometimes in the professionals, that nothing gets settled. But statistics across the courts, which is reflected on the government website, that how many matters have been settled, the amount is quite a lot. So when I was having training, the figure stood at a national level 29%. And at the level of the Supreme Court, it was 24%. So the worst performer was the Supreme Court. The best performance was the trial court. The gap was very narrow. But if we take this figure in the context of the number of litigations pending, which is like lakhs and lakhs and maybe crores of the cases pending across India, and if we think that, assuming that 25% is resolved by the mediation, the number is staggering. So there are a lot of disputes which gets settled through mediation. And it's not that the parties or the lawyers or the judges who are making the effort of the mediation would go in vain. So the statistics support that the parties actually do settle. The only thing is, when do they settle? So sometimes when in the real life, if somebody gets injured, he is working with a knife, somebody gets injured, you don't feel the pain immediately. The pain starts coming in the body after, say, a few hours or few days, when the becomes sore or it start paining, swelling, etc., etc. So immediately everybody is in a rush, nothing will happen. This is true in respect of the dispute as well. When the dispute starts between the two parties, everybody has the feeling in their heart they can win or they are right. Since that feeling is immediate, it's like a wound, fresh wound, so they are ready to do anything. It doesn't matter how deep is the cut, what would be the pain, they are ready to fight. But as soon as the time settles, the parties realize that it's a painful process. It can't be remedied. There is no ready-made output because you feel you are right. So in a typical example, like this is not statistically proven, but my personal experience, in matrimonial dispute, the sense of never-ending pain comes roughly around 5 years. When the first dispute started, or when the settlement is signed or divorce is signed. So it takes the parties around 5 years to realize that if there is a difference between the parties, it's better to part ways or live together with the differences. Repeatedly, I'm giving the example of matrimonial cases is for the reason they are the most difficult one to sort it out. Take an example in IBC, if there is a dispute and you are negotiating with the financial creditor is normally the bank. One-time settlement scheme. If the bank manager gives the meeting, it's all right. If it doesn't give the meeting, all right. You can directly negotiate on the numbers. And when the commercial terms fall in the line, maybe one day it gets settled. There is no convincing involved as such. Both the parties is looking at the balance sheet, how much I can give, how much I can take. There is a rationality, how much it could be recovered, and many other things. So in commercial dispute, it's easier to convince the parties. In matrimonial dispute, it is the very difficult one because everybody feels right. Second reason of giving examples of the matrimonial dispute is that they are purely subjective. Subjective in the sense that a lot of complaints which comes before the court where the wife is alleging that the mother-in-law is something saying one thing, another thing, asking to do work and etc. Sometimes the mother-in-law complains that that particular lady is not waking up at the time and not doing. Both are right. Everybody is right. Since everybody is right, one person's right is wrong for the another, and one person's wrong is right for the another. Therefore, the law as a subject is a very subjective thing. Being subjective thing, for the same thing, the two persons have different perception and both are right. For one person, the glass is full. For one person, the glass is empty, half full. The concept is the same. And that's why the reason, even in the court system, it's a 3-stage filter at least. For example, in IBC, NCLT, if NCLT gives a judgment, NCLT can reverse it. It doesn't mean that the NCLT was completely wrong or that judges should be penalized. No, they have made a decision which they thought it right. The second stage filter is NCLT. They might reverse or confirm the judgment. It is further could be scrutinized by the apex court, and they can come out with the third interpretation. This very 3-stage process is there because it's a subjective subject. And therefore, in order to adjust the people's narrative or do justice with them, it's essential to understand their pain. And this pain can be actually understood in the context of mediation easily rather than in a contentious litigation. We have, as an insolvency professional, or you as an insolvency professional, have seen multiple cases where banks are filing recoveries against these things. If somebody scrutinizes the balance sheet or the way the loans are structured, one will notice that first the interest is charged and then the principal is paid. The money is very neutral thing. It doesn't know whether it is interest or whether it is a principal. It's only the booking entry which is making the difference, that this 500 rupees towards interest, this 500 rupees towards the principal. So if somebody have taken a loan for say 20 years, for 10 years he has been paying 100% of it. What actually in the banking books is showing that the 0% of the principal amount has been paid. And the person is thinking that he has paid half of it. So these are the perception differences. Another thing in IBC, just taken even in case of financial creditors, there are lots of penalties and there are lots of book entries. So a loan coupled with the penal interest and compounding becomes huge. So original amount may be 100 crores, but when at the time of the statistics comes before the NCLT, it's 1,000 crores of rupees of loan. And in between, there are multiple settlements. The people say that the full amount was not disbursed, business lost. Since there was a loss of business, could not repay. When they were trying to give the loan, they were chasing, take a loan, take a loan, take a loan, take a loan. I took the loan. Business suffered. Now they are saying that they own everything which a person was supposed to be running the business owns. So in the metrics or in the scale, whether who is right, who is wrong, both the sides are right. Maybe both the sides are wrong. But these nuanced things only can come up in the mediation. So, one, it's completely secret. Two, the relationship is preserved. Three, the parties can freely discuss what is their pain point. And because mediation is only mechanism where you can go to the root cause of the dispute, the chances of reaching a settlement is more, which is long lasting. Why I'll say long lasting? For two things. If the parties willingly sign a document, this is what I want to give and this is I want to take, they morally feel bound to honor that particular settlement. So the chances of further dispute is really less. Secondly, by law, there is no appeal provided. Nobody go to any court against a settlement between the parties. So once the party has signed the settlement, he cannot say, I do not want to comply, though I have signed this document. That can be said only on condition if some extraordinary situation exists. For example, it's an extreme one, but for example, somebody says that if I do not sign the settlement on that particular day, they were going to kidnap my family members. Okay, that's an extreme situation. The court can revisit the settlement. But in normal situation, no court will ever touch the settlement. So it's a long-lasting peace between the parties. So those are some of the key benefits of the mediation. Now, coming back to the process, how the mediation should be done. So far, do you have any questions? Sir, Yogesh ji, any question? Kashi ji, Kashi Vishwanath ji, Vishweshwara Rao ji, any questions?
No, sir. No, sir. No.
Ask something, it will help me.
No, we are interested in one point. You said some committee where we have to do some course to become
Yes.
the arbitrator. That committee we are more interested in knowing.
Okay, so all the IPs are very conscious about the monetary part.
Monetary part. What IP monetary part, sir? Come on, sir. You know very well about it, sir.
No, it's not about you, the people discussing money.
IP
Very
what monetary
professional,
part?
sir. Not only IPs,
IP, we
even,
keep paying only the renewal fee.
That's true. That's true.
We are very prompt in paying also.
No, my question is, sir, you said that settlement, if the settlement has been achieved, then it has to be taken to the court. It can be taken to the court. If there is
Right.
no settlement arrived, whatever negotiations that had taken place with the mediator, they should not be disclosed even to the court. Why?
Right.
Excuse
So
me.
yes, ma'am.
See, when you were talking, I was under the impression if nothing is written, you say when I submit a report, I am supposed to say that whether it got settled or not. Not more
Right.
than that, right?
Right.
But in these cases, please don't mistake me. My husband is also an advocate.
Right,
See,
ma'am.
you say a mediator, right? There is then in future, or if the mediation goes for some time, there is every possibility for a mediator getting into collusion with one of them. So how get recorded? You're getting my point, sir? Have I conveyed you properly?
Like I understood the part that if the mediation takes a very long time, there are chances that the mediator get influenced.
No, there are chances, not only getting influence, there are every chance after third year or fourth year, A may notify, the word maybe agreed for some settlement, and after a point of time, there is every possibility for him to say that no, I have not accepted it. So if nothing is in return in writing, if it is there in writing itself, we will do so many things. So how does this help? Just for me to know, nothing more than that.
Okay, so I'll tell you how exactly it works. So first, I'll answer all the three questions in the sequence. So all the questions are answered. So first, taking the question of the training.
Yeah.
The question, the training is given by MCPC. MCPC is a committee in the Supreme Court, and they organizes training across India in the high courts, in the district courts, or wherever a request is made and they accept it. So what they do, they call from the existing pool of the mediators, and these people book a venue or something, hotel or something. Everywhere there is a different process. So venue is arranged for 7 days. The people's stay is arranged, or some place is taken where the people can attend classes from morning to evening. 7 continuous days, the people come and share their experiences. Sometimes it includes the doctors, psychologists, lawyers, judges. For 40 hours, they talk on different subjects. Once you complete that training, what they do, they have a practical session. The practical sessions is minimum requirement is 20 mediations, in which the 10 has to be successful. The 10 can be unsuccessful. And once you complete those 20 mediation, they impanel you as a mediator wherever is the vacancy is available. So it can be a district court, it can be a government mediation. So in Supreme Court, High Court, wherever it is. And that is how the entire system works.
Sir, yeah, carry on.
So that's the MCPC. Next thing which comes in the mind, is there any formal application advertised or not? So my experience so far has been, in all the courts, they pass the note on the notice board. The training is going to be organized. You can make an application. Depending upon the availability of the slot, you can get it. If there are more number of slots, they are screening the people who wants to take the training. But there is no number of vacancies, so it can be unlimited.
No qualification. Is there a basic qualification required?
Right. So most of the time they are only taking the professionals and sometimes the psychologists.
Okay. Sir, I have a question.
So other than that 40 hours qualification, who can do the 40 hours training, there is nothing specified as such. But they are only taking up those people who have spent significant amount of time in alternative dispute resolution, or they feel that the person has the subject matter expertise and can actually contribute, they can take it. There is no restriction.
Sir, there is one site, Nivaran, that is also of the Supreme Court, I think. And they are saying that there must be, they conduct some pre-aptitude test or something like that before going for that 40-hour workshop.
No, so far it was not. I did my training. There was no written test or something. So I applied at 2 places and I have a different experience at both. So I applied in Delhi High Court. I applied in the Supreme Court. So in Delhi High Court, the number of applications were huge and the slots were 30. And there were 1,000 applications. So they took interviews. And after interview, they selected, I think, 30 or 60 people whom they have decided to give the training. In Supreme Court, the slots were, say, 60 or maybe 70, 80 people applied or 90 people applied. So they divided into 2 batches and gave training to all of them. So it really depends where you apply and how many numbers, like how much food has been arranged, how big is the venue.
And for attending this 40-hour course, there is no need of doing any certification course or anything, nothing. Only graduate is enough or a professional is enough.
First, no.
Normally, they are taking only professionals.
Okay.
Apart from the professionals, they are only taking psychologists, like they are like altogether differently.
Yeah.
Others, nobody is making application, I think. But I haven't come across where a person has been rejected on a particular kind of education. So this answers the first question of Mr.
Okay. Ramakrishna.
Ramakrishna ji. The second question was regarding
Settlement taking to the court.
settlement unsettled thing. And the third question and the second questions are somewhat related, but not exactly. So how the system works. So take an example, a mediator is doing a mediation, party A comes and B comes before them. There are 5-7 sessions. Earlier, there was no time frame. And actually in Mediation Act or court rules, there is no time frame prescribed. But lately, a practice has been developed in the courts where they say that come before next date of hearing or give the report in say next 1 month or 2 months. So the time frame is gradually coming in these proceedings within which a report has to be made. Say in that during the process, you had 5-7 sittings with both the parties, one party, party 1 and party B. Both the parties leveled allegations. They fought like anything. Sometimes one has to be careful. In one of the mediations I was attending, the wife beaten up the husband like anything in the courtroom itself. But one has to be really careful, like what kind of things can go between. So after that, the two reports can be prepared. One is of the settlement, one is of the failure. In case there is a settlement, the parties may come with a draft, or they can tell the principal terms and conditions of the draft to the mediator. Then a document is prepared. This particular document has the necessary clauses which is set as a standard by the mediation center. Say, take an example, no conditions could be waived. The parties will not shout on each other. Okay, that's all right. But how to implement it? There has to be something tangible. Okay, the parties promise to give 1 lakh rupees when, where, if not written, then the mediation center will say, no, this is not fine. So there are certain things which the mediation center checks whether those terms are certain, implementable, and court will approve them. So after mediation, after the award, after the contract between the parties come before the mediator, the first scrutiny is done by the mediator. Mediator sends this draft to the mediation center, where the second round of scrutiny takes place. In the second round of scrutiny, if there is some further objection, like the signatures are missing, the advocates has not been signed, or the parties have not been properly identified, so all those objections are again pointed out, they are further cured. Once both the things are cured, like the mediator is satisfied, the mediation center is satisfied, then the parties sign and so the mediator along with the lawyer. These people put their signatures on this mediation terms of settlement. Then it is sent before the court, the settled one only. It goes before the court further scrutinizes it, and if everything found in order, sometimes they take statement of the parties to whether it has been signed by you, by your consent, whether you have any objection to it, whether there is any pressure. Once the court is satisfied that parties have willingly signed it, then they approve and it becomes decree of the court if so written in the agreement, or the proceedings are withdrawn if so written in the agreement. So both the consequences could happen. One, if the party says that we don't know whether other party will follow it, make it a decree of the court, we are ready to pay the court fees or the stamp duty on the award. Okay. So if they are ready to pay and they want it to be paid, the court make it a decree and it comes as a decree sheet. If the party says that say there's a matrimonial dispute, one party has filed proceedings, criminal proceedings, they simply withdraw the criminal proceedings and matter ends there. So that's all the steps when the matter is settled. In case the matter is not settled, say after five sitting, and there are allegations of biases. And in fact, the people get biased. It's very natural. This is answer to the ma'am's question. So ma'am says that there is a mediator get biased or sides with one party. That's an impression which frequently comes into the mind of the parties. And the reason for this conception is that some of the mediators haven't got their training well. They try to become adjudicators. You are right, you are wrong, so make this concession. Once you say a party that you are wrong, then he feels that दूसरी party से पैसा ले लिया उसने. That's a very common allegation. Okay, maybe he hasn't taken any money. There is hardly any money to be made in the mediation because the fees are very nominal, 10,000, 15,000, like that. It's more like a social service. So there are allegations which comes ki bhai ki the mediator is mixed up with the parties. So what is the solution? One, the mediator should be honest. If he becomes corrupt, there is no solution in the system. Like nowadays, like politicians, even the allegations comes on even on judges and etc. So there is nobody can say that nobody will become corrupt. But secondly, not only he should be honest, but he should behave in a manner which creates confidence in the heart of the parties that he is impartial. Since he is free to speak to both the parties, he should give equal opportunity to both. He should not determine, he should only suggest whether if you make this concession, your life will be good or not. So as long as he is giving equal opportunity to the parties, he is listening to both the parties equally, the chances of allegations are less. But it can't be said with the 100% surety that all the people or 100% of the people who are working in a particular profession follow the rule. That's why the mediation has built in, even if a party doesn't agree with a single line, they can say no. And it often happens that the parties agreed on broad terms of settlement. And when times comes to write down that settlement, there are so many nuances that it's very difficult to handle that particular phase of the mediation than the previous one. Take an example. If a party says that in a matrimonial case, so it's easier to explain. So husband agreed to pay 50 lakhs to the wife. Both the parties said, yes, let's go for the settlement and let's draft it. Once they sit down to draft the settlement, now the wife will ask, okay, that one particular jewelry which my mother has given and you took it there, now I want that back. Okay, so for wife, it is a justified demand. For husband, it is a 50 lakhs plus jewelry. And he said that I'll not agree. Okay, another instance, the custody of the children. They agreed on the amount. There is no dispute, no jewelry involved. They said that the child will remain 5 days with me and 2 days with you. Who will take it on the vacation? It's a very material thing. They can dispute even after that, even of the broad principal terms have been settled. Third thing, who will reside in that house which was purchased jointly, even if the amount has been settled? Or who will have their names frozen, or sometimes even nowadays like freezing of the eggs, and multiple issues are coming up. So the devil lies in the detail. That's why a constitutional or a legal safeguard is built in. If a party feels that the mediator is not giving a fair deal, or they feel that this deal is not fair for XYZ any reason, they can walk out any point of time and no questions will be asked. So that's an inbuilt safeguard. Nobody can force you. Even the judges can't say, no, you have to agree a particular kind of settlement.
This option is only for the parties, not to the mediator to withdraw.
Mediator can withdraw. Mediator, if withdraws, they have to inform the mediation center for XYZ reason. Suppose the mediator is not well, he is suffering from something or he is undergoing some operation, he is not available for 15 days, the time given is 1 month. Okay, he can write a mediation center, they substitute it. Not an issue at all. So mediator, in a institutional mediation, there is no bar on the mediator to withdraw from the proceedings like an IP.
Oh.
The COC can substitute an IP at any point of time.
But IP can't withdraw himself.
But IP can't do it. But a mediator can. If there is a conflict between the parties, suppose a mediator was an advocate or related to some party for XYZ reason, he can withdraw. He can give the reason and say. So there is no foundation like IP not to
Not
withdraw.
before me like.
No, not before. It's not before me. Okay. So I think all the questions have been answered. Or anything remaining?
No, only thing is that suppose if the unsettled part contains some terms and conditions which the judge may take into consideration while taking his decision, that is why it is not being escalated to the judge.
Right.
What is the problem there?
Yes. So take an example.
The confidentiality breaks there, I think.
No, bias is built up. The bias is built up. Take an example. If a person says that I'm entitled, I have a check of 10 crores of rupees, I am entitled to recovery of 10 crores. But in mediation, he says that, okay, he has given the 10 crores check, but isme itna black ka tha, itna white ka tha, aur check mil gaya. But whether the judge can say so. And if the same thing goes before the judge, he will get biased. Ye to illegal danga kar raha tha, kala money tha iske paas. It's a black money altogether. Okay.
So, but it can be done in the mediation part.
In mediation, no
both the parties agree some black and white transactions, it can be done there. But it
in mediation, there are people who says that that this much of the money I want to give. So some of the terms which they don't want to take before the court, they get executed even before the settlement.
Which will not form part of the
official document. So it sometimes something is like these are the practices which are not completely legal, but they do happen in practice. Take an example, you want to buy a property. Okay. That property was purchased by the previous owner in the same year. And he is an NRI. I'm making it extreme so you can gaze it. NRI who purchased the property for settling in India, now the situation turned, his business has gone down. He wants to sell that property. So if he sells the property, he is a USA resident, he sells the property, he has to pay the entire tax, which is 23%. Plus stamp duty, which is in some state may go to 10% or at least 7-8% is sure. So 30% or 40%, he will actually lose the money. So what will the option will be? Some of the people will suggest that, okay, take say 30%, 40%, 50%, get the property registered at the value of the circle rate. So the people do pay in cash and get the document registered at the circle rate. In the mediation also, sometimes the people do agree that those things which could not be said before the court. Okay. In some of the proceedings, the allegations of the wives are like that the man is important. Then they still want to reside together for monetary reasons. Okay. Maybe they still want to have the child custody, which they got it through IVF, despite impotency. Okay. All those things may not form part of the official document or the parties don't want to make them official.
So purely personal.
Purely personal. So the parties write only those terms which they actually want to enforce through the court in the final settlement document. It answers, sir? Anything
Yeah,
more?
yeah. So well.
So, so this was the broad contours, how the mediation actually take place and what the role of the mediator is. In the first meeting, when you will become a mediator in future, or if you attend any of the meetings, one of the first duty of the mediator is to introduce himself to the parties and parties to the each other. This is a very important step. Why? Because the third parties actors come into play which otherwise do not exist in the court proceedings. For example, in a matrimonial proceedings, the dispute is primarily between husband and wife. But normally uncles, aunts, in-laws, mamas, they do come to the proceedings.
They are permitted?
They are permitted.
Okay. I thought it is only tripartite thing.
No, never. So if unless the other party objects, I don't want any third party in the mediation, these parties do participate and actually they are crucial in making the decisions. Even in business dispute, so there was a dispute between the two business people and for negotiation, the wife came, who never ever was part of the transaction ever. So sometimes the third party's roles become really crucial and they do participate. And even for the first time, these parties are looking towards each other for the first time in the mediation. Maybe they have fought over for 10 years, 15 years, or 20 years. So first thing, introduce between the introduce. Once the introduction is complete, say you have introduced all the parties who are present there, the lawyers, etc. The next thing one is to do is to declare their independence as a mediator. He is supposed to explain that I do not have interest in the dispute between any of you. If you feel that I'm biased in any manner, please tell me so I can withdraw, or you can have another one, or if there is any reasonable doubt. Sometimes you happen is like some of the people are very rich. Nowadays, some of the judges are also very rich. Some of the mediators are very rich. And they don't even know the person who is coming before them is a promoter of a company whom they have a significant shareholding. That's also a conflict of interest in the commercial matter. So there are multiple instances where there could be a conflict of interest. There has to be a declaration to be made to the parties that there is no conflict of interest between the mediator and the parties, and there is no connection with the dispute. It creates two things. One, it makes the system transparent, and it instills a confidence in the hearts of the parties. Okay, he is impartial and we are free to speak. Once that part is over, then the mediator is supposed to explain that all the mediation proceedings are confidential. Because as you people, some of you attending the seminar may have the doubt, invariably some party will ask you a question, what if I say and tomorrow he will go before the court and he says that this has happened? So there, it has to be told to the parties that you can say anything and whatever is said here will remain here. It will not go out in any manner.
Suppose in this process of mediation, suppose if one party wants to speak in the absence of the other party,
right?
Should it be allowed? It should not be.
Right.
Suppose if he wants to be more, transparent in the issue, in the absence of the other, that can it be accepted?
Yes. So that's a very valid question, and it's really important question. In mediation, there are two types of sessions. One is joint sessions and one is single session.
Okay.
Joint session is one when you speak in front of each other. So the first session, when you are introducing the parties, when you are declaring your independence, where you are telling the benefits of the mediation, this is a joint session where all of them should be present and know these things. Thereafter, the mediator takes a single session of each of the parties. In the single session, the parties have many questions to the mediator, and they are not ready to disclose even to the mediator, and they are not willing to disclose anything to the other party. They feel that they will lose a particular strategic advantage which they might have in the case if this particular things go out of their mouth and become known to the other party. That's very human. So in those single sessions, the first thing the mediator does is tell them, one, whatever you say will remain 100% confidential. It will not go to the other party or the judges. Only the things which will be told to other party, which you allows the mediator to disclose to the other party. This has to be very categorical. If you don't make that statement, the party will not disclose their fears, and you will not reach to the actual crux of the dispute. The mediator, like there was an old story. The story was like this, that a craftsman prepared 3 statues which were identical of a human and took it before the king. And so the king wanted to purchase only one out of those 3. And he asked the wise men in his courtroom that, okay, tell me which one is the wisest choice out of all those 3. So the wise men took some, say, coins or something in hand, put in the ear of one of the statues and bent it, like whether it will fall from the other side or not. So in one, all came from this side and put from one side, came out from the other side. In second, few came. Third, none of them. He says the third one is the best one because it's completely silent what the other person is doing. So mediator has to be like that. He should not disclose one party's secret to another unless the party disclosing the secret says so. Typically, what happens is in practical scenarios, in the single sessions, this question automatically comes: if I tell the secret, what will happen? But the surprising thing is that normally the other side always know all the secret.
He
So,
feels that he is not, he
yes.
doesn't know it.
So my experience is that whenever a party says that this is my secret, the other party doesn't know. The other party knows 10 times more. And that actually tell. So in the second round, you just have to say and tell them, Kare, he said these 10 many things about you, and he says that he knows all that. So
Chances of misunderstanding will also be there.
yes, the parties knows the weakness of other very thoroughly. But to answer your question, whether single session or joint session, both the sessions are permitted. It is for the mediator to decide in consultation of the parties which sessions to be taken first, which sections to be taken at last. Sometimes the cases get settled in the single sessions. Both the parties says, okay, I'm ready to give. Say he says the 50 lakhs, other says 40 lakhs. Then you suggest, okay, 45, 45, 45. Okay, done. We don't want to see each other. We don't even want to meet. And sometimes the cases get settled in a joint session where the parties can freely discuss and they say that, okay, you know this, I can do this. So there is no absolute rule, but as a matter of principle, the mediator is duty bound to protect the privacy of the system, and therefore he should not tell one secret to another and only pass when the consent is given. Okay, sir?
Yeah, got it.
Right. So in the process, we were that introduction, confidentiality, single and joint session, and what will be the final outcome and how it will work has to be explained to the parties. Then there has to be single session and joint session depending upon the situation. Then what do you do actually in the sittings? The first thing in a mediator, it's not officially written in the documents, but to my understanding, the mediator has to be a person who speaks the least. Because good number of the time, the parties feel that they have been fighting with each other, say, for 15 years, 20 years, 10 years, and the judge did not give them the opportunity to say something. That is one of the prime thing which they want. Unka dard kisi ne nahi suna. Nobody listened to them for so many years. So they are, yes. So they are just there to tell everything. So who said what has happened, what has not happened, what personal difficulties they face. Other parties have no meaning with them.
That's why I think the mediation takes place outside the courts. So
That's
that
why it
everyone
takes out.
feels very comfortable.
Right.
Parties will be more comfortable if it is not a court.
Yes, the parties feel comfortable, and the mediator has to listen a lot of things which are completely irrelevant to the dispute. So, may on the session goes for half an hour, 1 hour, 2 hours. You have to listen, and in those things, you get to know what is the underlying problem. So, in one of the interesting cases which you are told by our teacher in the mediation classes, that husband and wife filed cases against each other, 4 or 5 cases. And they were coming every day to the court and talking to each other and attending all the mediations. And in mediation, they were not speaking to each other like they are sitting with the family members. So once the mediator decided to take their individual sessions, what is this? What is the dispute? So they said there is no dispute. Then why are you fighting? So there was no answer coming from the husband. Wife also no answer came. So mediator in a joint session told that I don't feel you have a dispute. Tell me really, why are you fighting against each other? So suddenly the wife prompted and says कि सास मिलने ही नहीं देती, यही तो मौका है मिलने का. That was the only occasion they can meet. Okay. So sometimes the moral of the story is sometimes the dispute appears to be something else on the papers, and underlying interest is something different. So in mediation, you can look to the underlying interest, which can't be done in a formal setup.
Yes.
Another
more
thing,
open.
It's more open. What happens that all the dispute systems, which are, whether it's a common law and civil law, the system is designed like this, that you have some grudge, you go to a professional who is eloquent, can present your dispute really well, your point of story. So he makes a beautiful story, and instead of your dispute, you start believing in his story. So if a wife goes to a lawyer and says that मेरे को प्रताड़ित किया गया है, I have been harassed. So the lawyer will write, she has been harassed mentally, physically, emotionally, and she is coming to a point of breakdown. She starts believing that, oh, so many things has happened to me. So the media, yeah. So there is a person who is fortifying your internal belief in a particular direction. In a mediation, since there is no need for lawyers, and even the lawyers feel that there is no need to say that you are right, they are the most supportive of the process, and the results comes out really well. So that's the difference, and that's how this process is more suitable for many kinds of disputes.
Like a street panchayat.
Yes, it's also a form of mediation settlement.
Maybe the source of this entire mediation is also, I think, street panchayat that happens in villages.
May say so. may say so. That's a hybrid where part adjudication, part mediation happens. It's pure mediation is pure settlement. Now coming to the crux of it. So what exactly, like one, you listen to them faithfully for a very long period of time, so the brings out. Secondly, a mediator should never become judgmental. He should never impose his own ethics on the parties. Because some person in a particular situation takes a particular decision, in a hindsight, you can't say whether it was a right or wrong.
Situation we are not feeling.
Yes. So in a commercial side, say somebody has not paid the amount. The mediator should not say, okay, you pay the amount, you have done something wrong. Mediator should say, what was the reason and how much you could pay. That could be the point of starting, rather than saying that in law, since you have not paid, you have agreed to pay.
You
So
to pay, you have to pay.
You have to pay. So mediator should never become the judgmental. If they become the judgmental, the allegation will come against them. He is biased. He has taken money from the other side for the recovery. Maybe he has some kind of percentage set up. All kinds of allegation might come. So there has to be no judgment. So if you can't pass a judgment, and if you listen, what you are supposed to do, why the parties will settle. So you have to give them suggestions. You have to tell them, if you do so take an example in a custody battle. If the father is saying, I want 50% of holidays, the mother is saying the 50%, and they said that Saturday is yours, Sunday is yours, then the things will get, everything can't be divided right half and half. They have to give a practical solution. Okay, first 6 months you, next 6 months you, whatever it may be, whether it suits you. It should be come in the form of the suggestion to the parties. So the parties doesn't feel that the person who has been appointed as a neutral is biased towards one party or another party. That's what is the crux of the thing. Now, another thing is, if he is listening, if he can only make the suggestion, how he convinced the parties to reach at a settlement? What is the negotiation between the parties? So the role of the mediator is to guide the parties to take a rational decision in that particular situation. So there is a nomenclature which is being used in a lot of these classes, Batna, Matna. But leave the nomenclature. One has to explain what is the best possible outcome and what is the worst possible outcome of a case. And that has to be told to the parties. So assuming if one party wins, the answer to this question will remain the same for both the parties. And it really helps in bringing the parties together to a midpoint where they are willing to settle. They have to be told that if one party wins, these are the reliefs the court is going to grant. And if other party wins, these are the relief which the other party is going to get. Whether you want to take the risk of fighting for next 15 years to reach that conclusion, what is the time cost? What is the monetary cost? What is the emotional cost? What are the benefits if you win? And in winning, how much you lose? Because say somebody is fighting in an insolvency proceedings for 100 crore of rupees against a promoter. So the mediation, they are also bringing mediation to the IBC and etc. The bank has filed 100 crore. The promoter says that even total worth of the asset is 10 crore. You take the 10 crores, if you don't take a crore, make the company insolvent. So the commercial interest, and the bank says, no, I want to go recover 100 crores. So what is the cost implication? What is the CIRP cost? How much will the resolution plan fetch? How many transactions can be proven in the 66 applications or avoidance applications? All those things have to be put in very categorical terms before the parties. These are the risks involved. And they have to be told very categorically that the legal system is inherently subjective. One party can reach one conclusion and another party can reach another conclusion on same set of facts without any variable involved. That happens often in court. And in the three-stage process, you don't know when you will get the success ultimately. In the IBC, they did a great thing putting a timeline, but whether it is practically possible to adhere those timelines, 50 cases listed before a court, humanly it is not possible even if judge wants to read them. And each case has like 50 applications or 100 applications. If it is a home buyer, forget the number of applications, how many it could be. So these are the things which has to be put up before the parties in the mediation and told the risk and rewards. So they can go and take a rational decisions. Next thing, a lot of these things the parties have never thought of. The parties, once they come before the mediation, they for the first time they start thinking of losing, winning, what could they get out of the mediation? Because till then in the court, they were only fighting how to win. And somehow there is a belief in their head or heart that by doing something, they can do something which may not be in accordance with law, or maybe more than what they can get otherwise fairly. Take a dispute between like neighbors. If one party wins and another wins, this doesn't end the dispute between them. The other party will keep on throwing garbage to the others. So risk of winning has to be told to the parties as well, apart from the risk of the losing, which everybody knows. Once they know their right and wrong, they get their priorities aligned, they get the time to think. There is no need to rush for the settlement. They must think through it and they take a rational decision, then the chances of settlement is more. So these sessions continue till it reaches to some final outcome, whether in favor or success or failure. Any questions so far, sir, by anyone? There are lots of participation, 19 people. Anybody else has a question? I think everybody has understood everything. Or
But you're creating a lot of interest in this profession.
no, it's good actually. Like I'm practicing in the Supreme Court. I started working as a lawyer in 2006. Frankly speaking, the satisfaction you get out of
correct.
once the settlement is reached, it's sometimes better than the sense of victory which you get when you win a case in the Supreme Court.
Correctly said.
It is something like you are walking on the street and you find a deserving candidate where you can hand over, say, rupees 10, 100, 500, whatever you want to give. And then a sense of satisfaction comes, which won't come when you are earning that 100 rupees or 500 rupees. So that's the difference between winning and getting a matter settled. And that's the beauty of this profession.
Yeah.
So as a lawyer,
involvement is there.
Yes, involvement, giving back to the society, then people remember you for if you are able to settle or not able to settle, but people will remember for rest of the life to you if you are fair to them.
Pro bono.
Which will not happen even if you gave them 100 crore recoveries. If, take an example, as a lawyer or as an RP, you get like 100 crore recovery for the bank will feel my case was so good, what did he do? He will never say that he made so many efforts. He will only say my documentation was perfect, that guy was crooked and cheater, NPA holder, fraud, assistant. He only recovered this much. But once as a mediator, you get a particular thing settled, that businessman or the person who the things get settled, he will remember for rest of the life, this guy has made an effort which made my life easier for years to come. And that makes whole lot difference as a profession, as a human being.
That is.
Yes, sir. Any questions, sir? No? Okay. So I think everybody has understood anything. Let's take 10 minutes break. I will rejoin
Yes.
and we'll restart. So I request that the topic is very limited. So come with as many questions as possible. And I will endeavor to answer all of them.
In your deliberation, will there be any court cases that are settled under this? We will be referring any court cases?
Like,
Case
I haven't
studies.
understood the question.
Case
Case
laws
studies.
only. Case laws. Yeah.
Case laws, I will send you one case laws, which is the landmark and which is the only case a mediator should know, is that he should not give the reasons on the mediation. Otherwise, there is no need to follow any law.
Okay. That is all instantaneous. I think that based on the situation there.
Right. So take an example. The law says that a person who has given the money is supposed to recover. Okay. That's the law. In IBC, the bank has come, Section 7 application, 100 crores, okay, has to be recovered. In mediation, you can say that the bank will pay 100 crore more so the business can be restarted. That thing can't be achieved in a formal setup.
Mm.
So that's the beauty of the thing. It can't happen in any other proceedings. So I will just take 10 minutes break. And so right now, I'll take it 4:30, 4:45. Let's take 15 minutes break. I will rejoin at 4:45. I'll
Okay.
request all of you to fire as many questions as possible. And I will try to answer all of them to my best of capabilities.
Yeah.
Yes.
Thank you. Hello, welcome back. Can you hear me?
Yes, sir.
Yes, sir. Yes, sir.
Okay. So request all 19 or 18 participants to ask questions as many as possible, and we will proceed further. It's not required to answer. All the questions are valid. All the questions are good. Anything, ma'am? Your husband is a lawyer. You must be having more questions.
You can ask questions.
Even he also deals with, he's a mediator. Let us mediate.
Okay. Okay. So, no questions so far?
No question.
Okay. So I'll ask the institution to say that I'm a very good person. Like the people get learn everything instantly. I say and they learn everything. So okay. So where should I start next? Okay. So I'll start. Whether is there any international framework in the mediation? So the answer to this question is yes. The mediation is recognized as a dispute resolution mechanism in most of the international organizations. So one of the key organizations is, say, World Trade Organizations. Nowadays, in the Trump era, like nobody is giving any importance to it because anybody can impose tariff as they want. But as the dispute resolution body is in the World Trade Organization is a hybrid of mediation and arbitration. Apart from the World Trade Organization, UNICITRAL also give the model law or the model architecture for the mediation. Apart from that, there are many international bodies which are promoting mediations. One of the, and some of them are recognized or have been given as a charter. Like there is a Chartered Institute of Arbitrators. They also provide many courses in international mediations and etc. So, and there are endless courses on the mediation.
Yes.
But in India, only one succeeds. That is given by the Supreme Court committee. Like that's the valid that will give you the work. Right now, the system works like that. If you get impaneled, if you take this training, automatically you get impaneled in one of the mediation panels, wherever like the vacancy is available or wherever they want to give it. So far they have been giving impanelment to 100% of the people who are taking these trainings. And if the marking process is fair, all the people are getting work. The maximum amount of work is with the government sponsored mediators, where they are working in the legal aid committees and etc. along with the government. I'm not sure, but I have heard that the Karnataka, the success rate is around 60% or something. Those are like, as an overall national average is also 30% in those committees. The caseload is highest. Then after that, the caseload is highest in the district court by default, because all the commercial matters has to be sent in the mediation. So obviously all the matrimonial and all the commercial matters and threshold is quite low, 2 lakhs and above. So every matter is going to the mediation. So everybody who is working in the mediation centers attached to the trial courts are getting a lot of work. Thereafter, the high courts, because many of the high courts in India has the original jurisdiction. Delhi has the original jurisdiction. Bombay has the original jurisdiction. Maybe some other high courts as well, Chennai, Karnataka, I'm not sure, but all those high courts which has original jurisdiction, the quantum of the mediation work is quite high. So there also everybody is getting work. In Supreme Court, the quantum is less, but there is hardly any mediator who has not got sufficient amount of cases where he can he can be busy. Monetarily, there is a Mediation Act, and there is a section in the Mediation Act which says that the cost of the mediations will be divided half and half between the parties. So actually, this cost is not determined so far by the parties, but by the government. So largely it is sponsored by the government, except for the trial court where they are asking for deposit of nominal amount of couple of thousands in Delhi district courts. I'm not sure about the other parts of India, but I'm sure the practice is more or less similar. However, every high court has different rules, so there might be differences everywhere. But when the parties are filing original suit, they are paying some amount as a mediation fee, whether it is success or a failure, irrespective of that. So that's how the work is being distributed. So if somebody becomes a mediator, the chances at this point is very high that he will get work. And he can, with perseverance, he can bring out the result out of these things. So
the process is time bound, right? The mediation process is time bound. So see, I'll tell you, I'm asking you, my understanding, please. See, actually, there is a case in front of a court. The court feels that it has to go to the mediator. Okay, so it appoints the mediator, right? It appoints the mediator. So at the time of at the time of appointment itself, they will tell very clearly within what time they have to come back. Right. Suppose in the process of mediation, there are the parties to the this process. They are not cooperating. They are not coming out with proper responses. What is the this one available for the mediator? Course of action available for the mediator. One. Number two is how long it is. Normally, what is the time limit that is given? Because see, one is the remuneration, the other one is the opportunities. The third is time. Time is very important. Time is the essence.
Yes. So first question was regarding the timeline. Is there any fixed timeline? The answer is yes, both in practice as well as in law. So in most of the court is giving specific time frame within which the mediator is give the report. In case there is a possibility of the settlement, the mediator asks the extension and some more time is given to the mediator, just like an IBC. That's the usual practice. The second answer to that first question of the timeline is whether statute provides it. Yes, Mediation Act provides it, and I think it's 120 days as per the Act. So within 120 days, the mediator is supposed to finish the mediation and give. So that's a very long time frame within which he is supposed. So both the answer is yes. Your understanding is absolutely correct. Now, the second question is regarding what if the parties do not cooperate? So that question is bothering the policymakers since the very beginning. Initially, when the CPC said Section 80 or something, when it says that the parties can be referred to the mediation, there is a line of judgment which came from the different court which says that the parties can't be referred to mediation unless they give a consent. Okay. So if they give the consent, the chances of their coming and not cooperating is very less. But now there is a change in perception where Mediation Act as well as the Commercial Court Act or many other legislation where they are contemplating to build in the mediation, they are making it mandatory for the parties to attend the mediation proceedings. So, for example, if in a suit which we have earlier discussed, like the mediation is compulsory, the practical how it works, unless they get a mediation report, the suit can't proceed further. So it will either, if the parties doesn't come, and it happens, like 70 to 80% of the cases, one of the parties never comes up for the mediation.
Even
So the
after
failure,
giving the consent, even after giving the consent, they don't come.
see, I'll reframe it. Consent was the earlier concept where the law did not say that you have to go compulsorily to the mediation. If the parties are giving consent, like in Supreme Court, what happens is there is no mandatory mediation. So parties give their consent. When they are giving the consent, 90% of the time they do come and attend the proceedings. Now, the second limb is when it is mediation is mandatory as a procedure. In a commercial courts act or under the mediation act or some other law, tomorrow if it may come to the IBC, where consent is not required and law forces the party to go to the mediation. So right now there are two, one is the proposal and one is the actual thing which is happening. The actual thing in commercial courts, normally one of the parties are not appearing 80 to 90% of the cases. So automatically the failure reports are given and the case are being listed before the court. So that's actually happening. What is the further proposal? In one of the discussions of some of these panels and the policy making division, there was a discussion that the parties have at least required to attend 2 sessions of the mediation before they decide not to cooperate. Okay. There is a third limb of the mediation. Mediation is even possible under the arbitration. Okay. In arbitration, there is a section which says specifically determination of the cost by the arbitrator of the arbitration proceedings. In the cost determination factor, there are multiple factors listed. Who delayed the proceedings? What was the arguments, whether frivolous claims have been made or not. In that, there is one column which says whether the party honestly tried to settle the dispute. Okay. If you don't try honestly and don't attend the mediation proceedings, the party makes themselves liable for extra or entire cost of arbitration if they lose. So all the 3 approaches are there, 3 or 4 approaches. One, when it is completely consensual, party refuses to say, the court doesn't send them. 2, when the law itself provides that you are supposed to go, and if they don't go, automatically failure report is coming. 3rd, in the discussion phase where they are trying to make couple of the sessions compulsory. And 4th, where if they don't, there is a financial consequences of not trying to mediate. So that's how the entire ecosystem is built. It changes from law to law.
Okay.
Okay, sir. Any other question? Really great question. The beauty of these things, like all the learned people come in those sessions and they ask really wise questions. And sometimes those questions when preparing for the session, we don't even anticipate or prepare. Yes. So no other questions? I think there is something in the chat. Okay, somebody has just given his attendance. Okay, so we have discussed, is there an international framework? And those are the international framework for the ADR. Then there are few important sections which as a professional one must be aware about are in the Mediation Act. So Mediation Act is 2023, very recent COVID, just post-COVID legislation. It is the first legislation on mediation in India. It defines mediation as the various forms of facilitated negotiation. So very crisp definition. Negotiation equal to mediation. There is no something necessary. Then they established a framework of pre-litigation mediation. There are pre-litigation and post-litigation mediation. Pre-litigation mediations are those where the court case doesn't go to the court unless there is a mediation. And post-litigation mediations are those where when the case is in the court refers the parties or parties request the court to go to the mediation. So pre and post, both has been thought of. The Act creates the Mediation Council of India. To my best of knowledge, it has not come into existence. But once it comes into existence, it's supposed to lay down various roles or something. It will be a body like IBBI, but maybe less
So
harsh on
what
the
is this, sir?
professionals.
In Hyderabad, there is International Mediation Center is in. I think
Okay.
the High Court is also
Okay.
given some judgment not to give the land to the Indian. Something is there.
Okay. So, well, we can work on conspiracy theories outside this session, but as far as the real thing is concerned, right now the arbitration and mediation is kind of Wild West. Wild West, as they call in America, like it's a free playing field. Why it is a free playing field? They did not lay down any framework who can open an arbitration or mediation center. There is no definite set of rule in India even today, whether if you want to open an arbitration center or a mediation center, what do you want it? So if there is no rule, anybody can do it. Like you can open yours, they can open theirs. So many of the people working in the dispute resolution framework have started their own center. Some of these centers have been started as per the CPC provisions when the Supreme Court directed to the various high courts. So Supreme Court in one of the judgments laid emphasis on the mediation and said that High Court should form. Delhi High Court was the first one. Now every high court or every district court in India has a mediation center attached to it. So that's under the government framework. The second set of those which have been privately established. So Mani Palkiwala Center, the Hyderabad Center. In Hyderabad, there are actually two. So one is some international, both are international, I think. One is run by, one is Mr. Retired Honorable Supreme Court Judge Nageshwar Rao is heading, and one is headed by someone else.
Okay.
Looking at the picture, the one headed by Mr. Nageshwar Rao looks more premium in a good locality, having huge space. And the other one is also premium, but not that much. So these centers are established as a standalone institution by the people themselves. There is no law under which they are required to register. They claim to be affiliated by Ministry of Law and Justice sometimes, but what is the framework is not very clear. Many of them are like, since it is a Wild West, set up their own. So if you go on the Google, there is one called SAMA, ACMA. It's an online ODR center. You can send the disputes to them. The charges around 2,500 rupees. It's extremely cost effective, actually. And most of the banking sector clients are giving their cases for mediation or ADR to these people. So one is SEMA, one is CADR, Center for Arbitration Dispute Resolution Center. That's some software company promoted. Then there is one in Chandigarh. All these are online centers. And in offline, like maybe 30, 40 or maybe 50 centers are working. So they have their own set of rules. If you want to establish one tomorrow, you can do. The only thing you require is the people who trust you to resolve the dispute. So there is no hard and fast guidelines. And it's
So it is actually legal, is it? Is it legal?
So in the text, like if you are a chartered accountant, cost accountant, and company secretary, you know that if so the law says that if the thing is not taxable, then it is tax free.
Okay. Okay. Unofficial.
It's official. So there are two set of laws. Say there is an Income Tax Act and there is a SEBI Act. Okay, or RBI Act to be more. RBI Act is works on the philosophy. If something expressly not permitted, it's prohibited. The income tax is just opposite. If something not taxed, you are free to do that act. So in
Okay.
ADR right now, there is nothing, but the law says there is something. So the new Arbitration Act and even in this Mediation Act, there is a proposal to set up the Mediation Council. And there it is the proposal to share the Arbitration Council. Both these councils are supposed to lay down the guidelines for the registration of the professionals and the centers and various other things. But since those bodies have not come into existence, right now everybody is following their own will. It's a free playground.
As on date, there is no regulation.
Right.
Yeah.
That's how it is working so far. So those who but you know, there is no regulation doesn't mean that the people have trust on them. The people trust, and these are the profession built on trust. The people will go and give their dispute only to the person who they have faith.
Trust. I agree.
So that's how the system is working. So in earlier discussion, one of the point I missed is the cost effectiveness. This is the most cost effective dispute resolution mechanism available anywhere. Because suppose if you
But
go
there
and
are two parties. See, there are two parties. And one party may be interested in going to a particular person. What is the necessity that the other person also has to come to the same person?
okay, great. So in case of voluntary things, the people can suggest the mediators. Okay, some of the mediators are very famous, particularly some of you
The
are
one
from
in Hyderabad.
Hyderabad, Sriram Panchu. So he charges more than the judges. Like he's very expensive mediator as such. Very famous one, very reputed one internationally. And I think internationally only he is famous. So there are only few people who made their name in internationally as a mediator from India, and he's one of them. So yeah, so cost effective in terms of the total cost involved. So if you go to a district center, maybe 3,000-4,000. In Supreme Court, High Court, it's absolutely free. You need not take your lawyers, anything. So it is one of the most cheapest, most economical way of resolving the dispute. So this is one of the key advantage of the mediation, which as a mediator, one has to tell the parties, why should you mediate? Yes, because there is nothing less costly than this. If you can't take benefit of this, nothing can help you in terms of cost terms. So if you really want to know what kind of future regulations comes, I strongly recommend you to see Section 31 of the Mediation Act. So that is something like every act has a thing where there is a rule making power and they give the heads. So here the heads have been given. You can go through and see that what could be the proposed rule. If whenever they are proposed, it will become more formal. But in my personal opinion, I feel that unless there is a standardization in the profession will not grow. So if like everybody is free to make their own recipe, then there is no standardization. And that's what is happening in the mediation or maybe in the litigation as well. As soon as the mediation council comes and it gives the standards, rules and guidelines, which everybody is supposed to follow, the trust of the people will increase. Just like McD's. Like they may not be making the best of the burgers, but the taste of burger is the same across everywhere. So people go there not because they want to have that taste, because they want to have that standard. So once those standards are fixed, automatically the work of mediation will grow. The people will approach to the mediation more frequently. So that's one part of it. Section 31 is then Section 18 of the Mediation Act, which talks about 120 days is completion timeline, extendable by 60 days, something similar
Same like IBC. Same like
yeah.
IBC.
They got the recipe. This is the recent trend.
Probably IBC would have got it from here. Would have
This is
taken the
20,
timeline from here.
this is
We-
23. So
This is
IBC was the
23.
prior one. Yeah. Um, so, and there is what kind of the requirement in the mediation things, which is also given in section 19. There is an inbuilt protection clause. Like now, if somebody says that how the proceedings are confidential, so you can directly take them to go read section 22. This is written in the law book. It will be confidential. So sometimes it helps. So it once happened that there was a client, and he asked me a question: why should I give my case to you? How do I sure that you will not divulge my detail to anybody else? I said, go and see the Bar Council Act. This is the rule where we are bound by confidentiality by the statute. So that's more higher than any confidentiality agreement you can sign. So similarly, in mediation, if anybody says that where that comes, so there is a section which is built which protects the confidentiality. It is section 22. Then another thing which comes in the party's mind, how it is enforceable. Why it is enforceable? So enforceable because the parties agreed. Why? How it is enforceable? It is a decree of the court. So there is in the CPC there is a section 12A, something like the IBC 12A settlement. There is also 12A, almost the same numbering of the sections. So here 90% agreement settlement happens. It's also kind of mediation. If you agree on the financial terms, 90% consent, stamp, no challenge. Here also, it becomes a decree. And in Mediation Act, it's section 27. It makes it a decree of the court. You can go and get it executed. And there is a limited ground of challenge. Those are like fraud, corruption, impersonation. So one is fraud. There is an interesting incident which also comes from a real life where like there was no solution. But it's interesting. So I'm just telling nothing related to this class, but it's a good incident which has happened. So there was a mutual consent petition was filed by husband and wife. So both approached to the court and they gave the statement before the court. One lawyer appeared from one side, the other lawyer appeared from the other side. The court asked whether you want to give the divorce. Both said yes, and divorce decree was granted. After 6 months, the wife comes and says that I went to a tantric or some jyotishi, and he told me that your married life will be happier if you give the divorce and remarry. And that's why I give and that's why I give the divorce, but now the husband is not remarrying me. So
husband is not?
Remarrying.
Remarrying the same person.
Remarrying the same person. So but the ground on which it can be challenged is the fraud, corruption. Corruption, when ma'am was pointed out, what if the mediator has sided with some party, modified the terms of mediation or something? Impersonation. Impersonation is also a very big problem. In Delhi court, it happened that the instead of wife, the people have presented some other woman to give the consent. And thereafter, the requirement of photographs came in. Aadhaar card and so some people got the divorce degree by filing the mutual consent divorce, but the lady was not their actual wife. And the court believed in them. So thereafter, now, if you see a matrimonial petition, the photos are fixed. So this is the woman, this is the man, and they have given the consent. So impersonation is also a major challenge. Unless the ground is so great, the mediations can't be set aside as such. So that's long and short of it. Any questions so far?
Actually, you said that the court will refer the case to the mediator, right? From
Right.
the and suppose the mediation fails, It doesn't go through as expected. It will automatically go to the court, or it has to go to the reconciliation, then go to the court.
No, it automatically goes back to the court. So as soon as the report is filed or not filed, in either case, in a time-bound manner, all the cases go before the court. That's a standard practice.
Manish, you mentioned about some Supreme Court case which every mediator should know. Did you touch upon it?
I'll give the name and the case citation. And thanks, Yogesh ji, after question ke liye, after a long time, you have asked something.
No, I was listening to your conversation. I was very useful, practical information which you're sharing. Very, very useful, So, but I thought not to interfere, because learned people were talking and speaking, so I thought not to interfere. But I think my interest was in the Supreme Court case. What did mediator should know?
Yes, so I'll give you the citation and case along with the email. Right now, I'm not recollecting the name. The fact was this, that a very known, very senior person was designated as a mediator by his reputation by the Supreme Court. And in the court's order, there was a direction to file the report. So that's a usual direction which is passed by the Supreme Court. But what the mediator did is, whatever transpired in the mediation, he made the entire report just like a local commissioner. That this was said by this party, this was the said, and this is the crux of the dispute, and it is not being settled, and etc., etc. So this report was filed before the Supreme Court.
So it was on sharing the specific part, not the whole story, basically, in the report.
The report, like whole or part, which the court doesn't know. The issue before the court was whether the mediator can give this kind of report when the mediation was unsuccessful. So the Supreme Court says that it is against the principles of the mediation that a mediator can give such a report, because this is not confidential. They have breached their confidentiality. So this is not acceptable. None of the material which is disclosed during the mediation is supposed to go before the court if mediation fails.
Okay.
So that was the crux and sum and substance of that case. The case I will give definitely in the email.
Because Google is giving two cases: B.S. Krishnamurthy versus B.S. Nagaraj, and the other one is Yamini Manohar versus T.K.D. Kirti.
Yeah, it's I think Yamini Manohar. Maybe both of them.
Okay.
And there is one Salem
Bar Association.
Afghans in infrastructure.
Yeah. So that's a perennial litigator in the Supreme Court. Madras Bar Association, Salem Bar Association. They are the most what we can say, that spirited litigators. Many landmark cases came from these two bar associations of India.
Okay.
So the relationship preserved. There is one more thing. There was a question regarding the joint session and single session. So mediation, there they call the flexibility of the procedure. This particular phenomena of having a joint session or single session or meeting a third party, which is not even a part of the dispute, this is called flexibility. So mediation gives maximum flexibility in resolving the dispute. So you can have one session, two session, meeting, joint meeting, consultation. In one of the cases, which is very famous case in the widely reported in Delhi newspaper, there was a doctor couple in Delhi, extremely wealthy, both. And children got married and everything, and then dispute arose, and they decided to file the divorce case. So in the mediation, the wife says that the husband gives me life threat, etc., etc. The husband says, I don't give anything. So either during the mediation or in the single session, the mediator discovered that wife has a fear of blood and husband is a surgeon. and both were the doctors, but because of that fundamental difference, they were not able to live together. So the divorce cases have been filed for this reason. Every time she sees something red, she feels it is a blood. She started shouting, complaining, etc., etc. And for husband, it's inevitable. She has to look after all those things every day, day and night. Ultimately, a very senior mediator in Delhi courts, she is very popular. She found a solution of their issues, which was like the same house will be shared between two of them, and unless required, no red thing will come from the husband's portion to the wife's portion. So they shared the same household and they started living together. And it was widely reported in the media. It's so ticklish case going on for 5-10 years, involving so many crores have been settled. So this do happen. And this can happen only when there is a flexibility of the process. In that thing, actually, the wife was required to meet some psychologist or something who actually confirmed that that thing was correct, that phenomena of seeing a particular color and association with something else is correct, and that's the real problem of the dispute, which has culminated in a matrimonial dispute. And that's how there is no rules as long as the party allows. You can consult n number of third parties, you can appoint expert. Sometimes the parties get the neutral expert within the mediators. So there are lots of things which can happen, and everything is allowed as long as there is a consensus between the parties on that mechanism. So that's called flexibility of the process in the mediation. There is one drawback of the mediation. So since we have so far discussed so many virtues of the mediation, we must also discuss the drawback. In one of the sessions, former Chief Justice of India, Justice Chandrachud said that there is imbalance of power between the parties. So in mediation, often what happens is some people are just the givers. Whatever you want, take it, but leave me alone. There are some people who say that I want everything in the world. So mediators are not supposed to adjudicate between the two, but they must warn this is what is happening to the parties. The party who is giving everything, tell them, no, you have legal rights. You exercise this discretion by discussing with the people whom you trust. At the same time, the person who is asking everything, you must tell them there are limits to what you should ask, and getting everything what you ask doesn't mean that you are making this thing permanent or solution workable. What happens is that, take an example, there are imbalance of the power otherwise as well. So there is an employer-employee dispute. So the employer can force the employee to enter into a settlement which is less favorable because he can litigate up to the Supreme Court, which the employee doesn't have the power. For employer, it is for setting the benchmark for all the people in the organization. For employee, it is his lifetime saving. So there is imbalance of the power. Similarly, in the consumer dispute. In consumer disputes, sometimes there is a fraction of amount or very small amount is involved. Suppose somebody has bought a fridge of say 15,000 and it goes into the mediation. So the company can fight up to anything in the National Consumer Forum, Supreme Court. But like going for the 10,000 in 10 dates, the people will lose their salaries, even a daily wager. It will be more than the cost of the fridge. And in those, power imbalance doesn't always yield the result which it should have. And that's what one of the drawback. The second drawback of the mediation is lack of precedential value. That's something very hypothetical kind of, or scratching the things, because every dispute is specific to the people and facts are different and so are the parties. But there can't be any benchmark can be set in the mediation proceedings. Okay, if this is the type of dispute, this much should be given. it can be done in the judicial proceedings and to some extent in the statutory arbitration. But in mediation, it can't be. Lastly, all the dispute can't go to the mediation. There are few which are statutory in nature, such like violation of the Competition Act, Companies Act, penal provisions. Those can't go into the mediation. But there was a judgment by Justice Ramanna where they have enlarged the dispute which can be referred to the arbitration, and same as applies to the mediation as well. So the number of dispute which can be referred to ADR is growing day by day. The broad line rule is like if anything which doesn't violate the law can directly go to the mediation, where the parties have the autonomy. So this is the broad rule, what can be done, what cannot be done in the mediation. Then that's more or less like I have covered what I intended to cover. If you have any questions. Yeah, I thought there will be a lot of questions, so I did not prepare that long a monologue. I thought I will
First
keep
of
it.
all, sir, I want to have your number, contact number.
Yeah,
I want
that's
to
what.
speak to you for some guidance.
Yeah, I mean, that's what I was going to ask. If you can share your number, Manish, that would be good.
I have just shared in the chat box.
Okay.
So that's my number. You are
Okay.
most welcome to come to Delhi. Come visit my office. Lunch, dinner, and coffee is from my side. On me.
And your office is where?
It's Lajpat Nagar 3 in Delhi. It's in close proximity to the NCLAT because all the IPs know the NCLAT. So it's less than 10 minutes from NCLAT. Principal bench as well as NCLAT, CGO complex. So, any other questions, sir? No? Okay. Is there any person here from ICSI? I guess. Ma'am, are you there? Institute?
Yes, sir. Can we conclude now?
Yes, ma'am. All the people are satisfied with all the answers, so I think I may conclude.
This is very subjective, This is very subjective.
Yes.
Sometimes, sometimes having no answers means either no one has understood anything or everyone has understood everything.
Well, I'm taking advantage of bias on my side. But if you have a question, I'm always available.
We are with
You got all the right to take that assumptions, No, but I taken your numbers and I'll be in touch soon.
Most welcome, Yogesh ji.
Okay.
And special thanks to all those people who have shown their switched on their camera. So I was able to last that long. Otherwise, it would. Thank you very much. Ma'am, you can conclude.
Thank you very much, sir, for such an nice and knowledgeable session. Sir, you are requested to share the material so that we can share with the participants.
Yes, I will share it tomorrow. Thank you very much, sir. And thanks to all the participants who remain invisible and
thank you, sir. It was very informative.
Thank you, sir. Sachin ji.
Can we leave the session now?
Yes, sir.
Thank you.
Thank you.
Thank you, Manish. Thank you.
Thank you, sir.